to the second African Arbitration Association annual conference. And I want to use this opportunity to welcome everyone from wherever they are linked up in the world to this second session. A big thank you to the organizers, and I think I must extend our appreciation to the President and members of the African Arbitration Association for the privilege and honor afforded us to be part of this session, and I in particular to being the moderator for the session. We have a panel of distinguished African dispute resolvers and arbitration personalities to anchor and deliver on this session. The topic being dispute resolution in African regional investment agreements. We'll consider whether indeed these agreements are innovation or whether they are stagnation. We have an hour and a half for this session, and each panelist will have about 15 minutes to do their presentation, and we will reserve about 30 minutes for questions and answers. Participants are hereby please advised to please submit ahead of time the questions to the Q&A portion of the chat line there, so that we can know who your questions are directed at. And it will equally be appreciated if you determine, if you specify who exactly you want to answer these questions. To start off this discussion, as I said, we have an array of distinguished dispute resolvers within the continent of Africa. But Jacquel Ferries would start off the discussion for this second session. Jacquel Ferries is a partner at Clifford Deck-Hoffmer Incorporation, which is a leading African law firm. Jacquel is an experienced attorney providing dispute resolution, of course, both domestic and international, to clients in South Africa and various other African jurisdictions. He was admitted an attorney and notary public in South Africa, and his full resume can be obtained from the Hoover platform. And I will advise anybody that wants to know more about Jacquel to please check the resume as provided. But more importantly is the fact that he's going to speak to us on SADC investment protocol and the tribunal. So Jacquel, please, over to you. I yield the floor to you.
Thank you for the introduction, Chief Akinole. I really appreciate it. And it's really a pleasure to have been given the opportunity to be a speaker on this panel. As Chief has mentioned, we will be discussing and unpacking invested state dispute resolution on a multilateral level, not really focusing on a bilateral level, but touching on some innovative issues there also aspects. And then the question, is there stagnation or innovation? And also welcome to the attendees. Hopefully you'll find the session enjoyable and informative. So my session will focus on more the Southern African Development Community, in short SADC, in terms of what is happening from a SADC perspective in investment dispute resolution on a multilateral level. Is there any access to investor state dispute resolution on a multilateral level in SADC? If not, is that stagnation? And is there other avenues and options that are being developed from a SADC perspective If we look at the harmonization with reference to the SADC model BIT that has also been developed by the SADC member states. So when we talk about multilateral investment agreements and protocols, if we look at it from an African perspective, these are regional integration processes that have started post-colonialization in Africa in order to also encourage the development of the specific areas within Africa from an economic perspective. So we see the development of several regional economic communities. One of those is SADC, or the Southern African Development Community in the south, and you get a number of other communities on the African continent, the EAC, ECOWAS, COMESA, and so on. All of these communities, the fundamental basis of these communities, or economic communities, is to encourage economic development, investment within the region, and ultimately ensure that there's integration. But with that, obviously, there's also, when we talk about economic development and investment, we talk about the potential for disputes and the potential for intra-regional investors. So I will speak about intra-SADC investors in this case, where there's potential disputes that would come through the natural flow of any investment. What I'll also speak about at the end when we talk about the real analysis, is there stagnation or is there innovation, is the fact, how does all of this ultimately pan out for the AFCFTA investment protocol? I know there's been a discussion on that in a separate panel, but it's also important to see from a regional perspective how that the developments in the region affects what the investment protocol will ultimately potentially look like. So I start off with, for those who do not know, SADC. So SADC was established in around 1992 through the SADC Treaty. So as I mentioned, one of the fundamental purposes of this development community was to ensure integration, strengthening social and cultural ties, eradicating poverty, and a number of other social evils that we see on the African continent as a result of historical past and context through colonialization. Now, part of the SADC Treaty was also a number of institutions were created. And one of the pertinent institution is called the SADC Tribunal. And the SADC Tribunal was referred to in the SADC Treaty in Article 9 in terms of its establishment as a regional dispute resolution mechanism. But the tribunal has been very controversial, as those who follow the developments in SADC would have known. So the tribunal, just a brief, so it's referred to in the SADC Treaty in terms of it's a entity or institution that is created with reference to the main principal document, the SADC Treaty, but then it actually gets flesh only in the year 2000, on the 7th of August, where SADC member states then enter into a tribunal protocol, which then came into effect on the 14th of August 2001. Under Article 16.2 of the SADC Treaty, the Tribunal Protocol governs matters relating to the SADC Tribunal, such as the composition, the powers, function, and procedures. There's also, in addition to that, if you go to the Tribunal Protocol, you get Article 14 and 15 that deals with the scope and the basis for the SADC Tribunal to extend any jurisdiction for potential matter or issue that it needs to entertain. Now, when you look at the founding document, so this is the SADC Treaty and the protocol, one will see that it does not confer upon any investor any independent and enforceable right to refer an investment dispute to the SADC Tribunal. But strangely enough, if you look at the history of the tribunal, since the protocol was adopted, there's actually been a few cases that has been heard, I would say, under the guise of an investment claim. And the most prominent probably would be, we would all recall what happened in Zimbabwe in relation to the change of constitution, the expropriation of farmers, and there was a claim then that was lodged by Mr. Mike Campbell and a number of other Zimbabweans and other nationals against the Republic of Zimbabwe. And that claim was ultimately entertained by the SADC Tribunal, and the SADC Tribunal found in favor of these farmers and ultimately held that there was an unlawful expropriation by the Zimbabwean state. This also resulted in a number of other claims that the SADC tribunal was then seized with. And ultimately what happened is that there was a discussion and debate among the African member states whether the tribunal in its form it is should actually continue, because through political pressure, through Zimbabwe and a number of other jurisdictions, it became, I think, a problem, because you now had an institution that's fighting against African states and saying that certain things should be done, and corrective measures, in particular with reference to the expropriation matter. Another important case that also happened in the same period was, and a lot of us would probably know about it, is Swiss-born diamond mines. And I'm just giving you the context around the tribunal because it becomes important to analyze whether there's actually any form of ISDS in the SADC. So Swiss-born relates to also an alleged claim by an investor in relation to a mining lease in the Kingdom of Lesotho. Now, they lodged the claim sometime in 2009, also after the tribunal, a few years after the tribunal became functional, if we can call it that. But what then happened with the Campbell case, with the Swiss-born case, we can see there's a decision by the SADC summit to ultimately disband the tribunal. It became dysfunctional because judges were not appointed on the tribunal to adjudicate certain disputes. There was then also a long dragged out dispute. So the Swiss-born matter, it's a long history of about 30 years. We will call it a 30-year saga, but eventually Swiss-born relied on a new protocol, or the annex to the SADC treaty, which is the Protocol on Finance and Investment, which is the investment protocol, which has provisions that deal specifically with ISDS, or the referral of disputes through international arbitration. Now, to just cut the entire story, there was ultimately a dispute called the shattering dispute, which went on review to the Singapore High Court, and the Singapore High Court found that there was no jurisdiction with reference to the SADC investment protocol for a Swiss-born to refer the dispute to arbitration under the guise of Article 2028 of the investment protocol. But an important point, I would think, is if you look at the SADC tribunal, is what was held by the Singapore Appeal Court in relation to the SADC tribunal. And there's a decision specifically with reference to Campbell and why the SADC tribunal entertained the dispute. And I just want to quote this. The court says, this does not sit well with our finding that Article 14 and 15 of the tribunal protocol do not without more give investors the right to refer a dispute to the SADC tribunal. With respect, we doubt the correctness of those aspects of the Campbell versus Zimbabwe decision. So you can see when there was a detailed analysis by the Appeal Court of Singapore, the ultimate finding it comes to is that these instruments, although it's being used for purposes of by investors to go to this tribunal, the ultimate purpose of the tribunal, the SADC tribunal, was not for investor-state dispute resolution, but to assist nationals where there's, say, human rights abuses, to approach the tribunal, not as an investor, but under the specific terms of the treaty. Now, another important thing about the SADC protocol, before I move on, is also this then culminated in a dispute in South Africa, where South African, also Zimbabwean investors approached the South African court in relation to the disbandment of the tribunal. And our constitutional court says that South Africa's participation in the disbandment of the tribunal was unconstitutional, and it had to essentially withdraw its signature from the disbandment. Now, we can see the tribunal itself, up until today, I think there's processes in place to make it functional, but it's totally dysfunctional. Now, with the dysfunctional SADC tribunal that is meant to either resolve investment disputes or other types of disputes flowing from human rights issues. We can see there's not really any tribunal that resolves disputes on a multilateral level. Then we look at the SADC protocol in finance and investment, and there's been significant development in relation to that also. And I'm going to be very brief. Initially, we had Annex 1, which is called the Cooperation in Investment, SADC Protocol Investment, which came into force in April 2010. That made provision for investors, qualifying investors. Initially, also we can have a long discussion about the SADC Tribunal in terms of its innovation initially, where as opposed to just restricting it to investors from the member states, it also had the definition included any potential investor in the SADC region. So it had access to investor state dispute resolution, either through exit, ad hoc tribunals. Then also as a result of a number of challenges, one of them is a Swiss-born challenge, and also challenges to the South African government, to the Foresti case and one other case. The SADC member states again decided, no, we need to amend the protocol on finance and investment and specifically exclude ISDS. So in August 2016, the SADC summit then proposed and adopted ultimately the amendment of the protocol, which removed ISDS as a form of dispute resolution, or international arbitration as a form of dispute resolution in the SADC investment protocol. So currently what we have in SADC is essentially, I would say, on a multilateral level, it's the only option that an investor or SADC investor, inter-SADC investor would have is you would have to go to the domestic courts. Or you would have to ask your host government, if you're a South African investor investing in Botswana or the DRC, to exercise diplomatic protection. But we've also seen the attitude of African states towards exercising diplomatic protection. In one case, again, is the Swiss-born case, where a South African investor who was the investor in Lesotho approached the South African state for diplomatic protection, and the South African state said it does not intend to do so. He took the state on review, and the court, because of the separation of powers, and this is ultimately exercising diplomatic protection is an executive decision, the court said, having regard to the reasons of the state, the decision of the South African state will not be reviewed by the court. So you can also see that, so that limits ultimately what there is. And this is different to what we see in other regions. So if we talk about ECOWAS, we talk about the Court of Justice, which actually provides access to investors to resolve investment dispute. We look at COMESA, the instrument which is not yet enforced, but it also refers to potential dispute resolution to the COMESA Court of Justice. So in SADC, with respect, I would say there's on a multilateral level, there's a stagnation of investor-state dispute resolution. With reference to the development with the SADC protocol, with reference to development with the investment protocol, and it limits the access of investors to what the host state provides, either in terms of their own domestic investment legislation, or other provisions, or if you have a separate investment agreement with the other host government. So it's not good for intra-Africa investment per se because of the stagnation. But having said that, and I'm almost done, we have the SADC model BIT, which has never been used. I've never seen it being used by any of the SADC member states. So it's a wonderful instrument which is innovative in a sense. It makes provision for more substantial obligations on investors. It makes provision for counterclaims by the state. In the event that there's an option in the BIT that has been elected, it makes provisions for amicus curiae, and a number of other provisions in terms of consolidation of arbitration and so on. But that is merely in the SADC model BIT, which is the election of each member state to decide whether they want to use the BIT. It's then in clear contradiction to what is happening on a multilateral level, where we see there's stagnation. Whereas on the SADC model BIT, which is also a SADC, I would say, project, you would see each individual state will have the option then to decide what their own BITs could be, but on a multilateral level, there is something different. Then, I'm running out of time. The conclusion then that I can come to is that if you look at it from a policy perspective, and I speak from a South African perspective, so the South African government has been not arbitration per se, but investor-state arbitration, because arbitration is a normal process for the resolution of disputes by the state in South Africa for commercial matters. There's a bigger move to mediation. And the question ultimately would be, if you look at the approach of one of the biggest economic players on the continent in relation to, we don't prefer ISDS as a means of resolution of dispute, we prefer mediation as a means of dispute, or you must come to our domestic courts. What will ultimately then be in the AFCFTA investment protocol? Will there be an option given to states, and how will that work? Will it be a separate annex to the protocol? So it will be interesting to see. And then you also sit with the issue of harmonization, where you have a suite of BITs, which says one thing that's inconsistent also with what's happening on a multilateral or continental level. So it will be interesting to see what will be the ultimate final investment protocol that is adopted by the member state, because there is different views in relation to how disputes, particularly investment disputes, should be resolved. And that there's a lot more to say, but I think I've run out of time.
Thank you very much, Jackwell, for that perspective of using the South Africa eye to the treatment of the investment agreements. The summary, the conclusion made by Jackwell basically is that in his own view on a multilateral level, that it appears it's a stagnation and not an innovation. It would be nice to have different views, because the array of presentation we have is an interplay of the talents, the great talents we have within the continent of Africa. Jackwell, thank you very much. As I said, please, to all participants, we expect you to please send your questions to the question and answer so that we can pick them up and get them prepared for our panelists to treat before the session ends. So please, ahead of time, we'll appreciate you sending your questions to Q&A. To give us another view, another perspective, is, to this good topic, is Dr. Sylvie Bebohi Ebongo. She's going to give us our own views using the prism of Cameroon. She's, as you get to know, Dr. Sylvie Bebohi Ebongo was called to both the Paris and Cameroon bars, so she operates in both jurisdictions. She's a research officer at the Association for the Promotion of Arbitration in Africa, APAA, where she acts as a representative of that association in Europe. She's going to talk to us essentially on the OHADA. I yield the floor to Dr. Sylvie to let us have a perspective using the Cameroonian views. Dr. Sylvie, please.
Thank you. Thank you very much, Chief, for that brief introduction. I would like, first of all, also to thank the organizers for inviting me to this second annual conference of the African Association, which is an African association where we have put a lot of hope for the development of arbitration in Africa. So it's very an honor to be part of this second conference and to be part of this very distinguished panel. As you just said, I will focus my reflection on OHADA on the perspective of our topic, which is to discuss about the dispute resolution investment settlement. And I don't know if I will do like Jack well by trying to answer if there have been an innovation or stagnation, but I will try to put myself on both because, and I will open with that. As many of you know, on 2017, OHADA have had an important reform of its text on arbitration, that are the Uniform Act on Arbitration and the CCGA's arbitration rules. For those who are not familiar with the OHADA arbitration system, you have to know that we have two instruments within the OHADA legislations. So the main reform of this OHADA text have been the introduction of investment provisions, because initially OHADA was set up just for commercial disputes. So we had that reform in 2017, and this is seen as an innovation. You have also to bear in mind that OHADA is a regional organization with 17 member countries, which are also member of two regional economic and monetary organizations that are the Economic Community of Central African States and the Economic Community of West African States. Therefore, OHADA arbitration has regional investment policy impact, if I may say, I can say it like that. So when I was given this subject, when I was looking into this subject, I asked myself, what have been the impacts of that OHADA reform toward the investment policy of these member states? And the reform came into force in 2018. And I asked myself, is that reform appear as a real innovation? What have been the evolution of the investment arbitration since the revision of these texts that are the Uniform Act and the CCJ's arbitration rule? And can we really evidence the investment arbitration in the OHADA landscape? So my presentation will be focused on those 2 points. So the first question, as I was saying, I asked myself was to know if the reform appears as a real evolution for resolving investment disputes within the OHADA member states. As I just said, OHADA has we have two instruments, arbitration instruments within the OHADA. But another important point you have also to bear in mind is that these two instruments are linked with the OHADA treaty, especially the OHADA arbitration based on the CCJ's arbitration rules are directly linked to the OHADA treaty. So you have to read Article 2.1 of the CCGA's arbitration rules with Article 21 of the OHADA Treaty. And when you read the conditions set up in this text, you have two main conditions for OHADA arbitration to, if you know, put if you want to be put in place. That is that the dispute must arise from a contract, and also that one of the party must have its residence in one of the OHADA member states, or the contract shall be performed wholly or partly in the OHADA, in one or two or many OHADA member states. But now when you have a look at the new article 2.1 of the CCJ's arbitration rule, you can see that there have been an add-up concerning investment arbitration, and the same add-up have not been made concerning the treaty. So you cannot have a revision, if you want, of a text which is based on the treaty without modifying the treaty itself. So that we still have a problem concerning that important point. Another point I want to stress on is that the two conditions I just mentioned, that is the domiciliation and the performing of the contract within one or many OHADA member states, have not been put on the new OHADA test. That is also a problem, because finally we don't know if these conditions have to be respect, or if it is open to people who are not staying within the OHADA member states. So for me, in a very personal point, I think, and many authors have also stressed on that, there is still an adjustment to make between the OHADA treaty and the OHADA arbitration text, being it from the OHADA, the CCJ's rules or the Uniform Act. The true reform of OHADA arbitration will be also to reform the OHADA treaty. That is the first point I wanted to share with you. Another point concerning that OHADA investment reform is that when you look in depth at the provision, you will see that there have been these two added provision, that are Article 2.1 and Article 2.3 in the Uniform Act. But when you look at the whole text, you will see there are some consideration concerning investment arbitration who are still missing. I will just take the example of transparency. You know that today the trend toward investment arbitration is based on transparency, because we have states who are involved and also public funds who are involved. So the use of amici curiae is current in investment arbitration. When you look at the provision of OHADA as they stand now, we don't have any provision on transparency, for example. And when you go further on that provision, you will see that all the old structure of the test have been left as it was, so that you just have a reference, reference to arbitration agreement. For example, if you look at provision concerning the joinder, competence, the autonomy of the arbitration agreement, interim measure, all are still focused on the what I can call the classical arbitration system, without taking into account the investment system. So this is, for me, is still something we have to perform, OHADA member states have to perform, to really make this a reform be complete. Another point also on that point is you can see that the name of the legislation has not changed. We still have the Uniform Act, we still have the CCG arbitration rules, and that can lead to confusion because, as I stated earlier, we had initially text dedicated to commercial arbitration. Maybe it have been more easier to have a legislation, a different legislation on investment, which will have been complete with all the requirements of the investment policy. The investment policy we have nowadays. Another point also, and that is also to do the link between this reform or this innovation or the inclusion of investment provision in the OHADA area, is that we don't see the real impacts of that reform. I will link that with the IESDS reform currently in discussion at UNCITRAL. The OHADA the OHADA test in arbitration has been reformed in 2017, the same year as this UNCITRAL discussion were implemented. I think the first meeting of the working group 3 was in the late 2017. But since yet, we don't see a real impact on the OHADA area, or they don't take a position. We don't have a clear position of the OHADA states towards that ESTA reform. I know that there has been an informal session where some OHADA member states were involved. There has been some discussion with some organisms like the African legal facilities, but you don't hear a voice, a unique voice on that coming from the OHADA member states. And for me, it's a problem because we are in a unified area and there must be a voice to share our view, a common view on the investment policy as is currently. It will be reformed by that ESD. But we welcome some position of states like Mali or Guinea, which are part of OHADA, who have submitted some draft paper to the working group. But since we have this organization, it should have been a good idea or a good thing to have a unique voice of what the OHADA member states who have broadened their the scope of their investment of the arbitration. It should have been good to have a voice coming from that organization which represents this country. Today we don't know where really we stand towards this ESDS reform. Having said that, I will maybe move on my second point, which is also another question I asked to myself. As the OHADA investment arbitration provision had a real influence on investment policy of OHADA member states. As I was saying at the beginning, OHADA is made also of economic regional organization, the ECOWAS, the ECAS with Central Africa. And we do have some text or instrument referring to investment within OHADA area. I will mention the Standard Convention on Investment, for instance, the CEMAC Charter of Investment, the Economic Community of West African State Supplementary Act. Since the adoption of the reform, we have not seen a change on that on this text. So there is not a real impact for now. We can really testify that could lead us to say that there has been a real impact since the adoption of the reform. These tests are very old. For example, the Standard Convention on Investment in the State of the Custom and Economic Union of Central Africa is a text dated of 1965. The CEMAC Charter on Investment is from 1999, and the Economic Community of West Africa State Supplementary Act is from 2009. So for now, we don't really see the impact of the reform, the OHADA reform on those texts dealing with investment within the OHADA area. Another point also that I want to stress is I've had a look on some bilateral investment treaty that have been concluded after the reform, and I can mention, for instance, the BIT between Burkina Faso and Turkey. BIT, which has been signed in 2019, BIT between Congo and Morocco, 2018, Ivory Coast and Japan, 2020, Mali, Turkey, 2018. When you look at those BITs, you cannot see a real impact. Why am I saying that? I saying that because in the former BITs, you will have very few reference. I think there are at least 2 or 4 BITs who make reference to OHADA arbitration as a forum an investor can use or can choose to sue a state. And you can see even in the new BITs that this trend has not changed. I can mention only the Burkina Faso Turkey BIT, where there is a reference to an arbitration center within the OHADA area, which is the Arbitration and Mediation and Conciliation Center of Ouagadougou. But the trend is still to refer to international arbitration institutions such as ICSID, ICC, or UNCITRAL. So if ourselves does not, because we are the one negotiating this instrument, does not mention OHADA arbitration within the instrument, the arbitration institution which can be used to resolve disputes arising from investment, for me, there is still a point, and there is still a work to do on that. That said, I don't want to appear like having a negative perspective, and I will end up with that. There has been a real innovation. The inclusion of provision on investment arbitration appears to be a real innovation. What I want to insist on is that there is still a lot to do to implement that innovation. And the first thing is to revise the OHADA Treaty. The second will be to, I can say, to try to insert also, or maybe to see if there is not a possibility to do a uniform act or a text dealing especially with investment arbitration, because investment arbitration is different from commercial arbitration, and there are some considerations that should be taken into, especially that has to be considered when you deal with investment arbitration. Another point also today is that there is a need to have a real investment policy within the OHADA member states. I was hearing Jack Well with the SADC, with South Africa, who have denunciated a lot of its varieties. Today, within the OHADA, we don't have a real policy. Do we intend to terminate the current variety and to negotiate the other ones? What about those who have been terminated? How the states intend to negotiate them? And it could have been good if there is a real regional policy coming from the organization, from OHADA itself. So I don't want to end in a sad note, because hope is permitted. A lot have been done, because before the inclusion of that provision, we will have been forced to interpret the text before accepting a dispute arising from investment. At least today, we have clear text stating that OHADA is ready to know about investment disputes. And also, we have some government who expressly encourages reference to OHADA arbitration in their investment instrument, even if they are still few. And we have also some OHADA states who have been chosen as arbitration seats. So I think if I can answer the question, I won't answer it clearly. I would just say there has been an innovation, but we still have to continue the job and to complete that reform and to make that innovation being a real one. Thank you so much for your attention.
Thank you very much, Dr. Sylvie Beboyi Ebongo. As participants can see, Dr. Sylvie actually struggled through her presentation because she couldn't conclude one way or the other. And in certain respects, she acknowledges the fact that the inclusion of provisions on investment arbitration appears to be an innovation in the OHADA investment dispute resolution landscape. However, in another way, she limited that innovation, and it appears as a stagnation that the innovation has limited impact because it remains unachieved. We will still leave room because you probably will still have an opportunity of hearing Dr. Sylvie have another 5 minutes for the presentation before the session runs out. Permit me now to have another panelist join the presentations. This one is going to showcase, perspective from Mauritius. I'm going to invite Andrea Lapozina Neronelli. I hope I didn't butcher that name. I shouldn't. I have no reason to. Neronelli, to let us have our views with regards to what operates in Mauritius. Andrea is a legal counsel and a representative of the Permanent Court of Arbitration in Mauritius, PAC. She's an astute dispute resolver, and she operates both from Mauritius and Paris, but a perspective of the Mauritius experience is what we would expect her to give us within this session. So I yield the floor to Andrea, please. We have you for the next couple of minutes. Andrea.
Thank you very much for those kind words of introduction, Chief Kabula Akinola. It's a pleasure to be here for the second Congress of the African Arbitration Association. And it's already been a pleasure for me to hear what my two co-panelists have had to say so far. It's important, first of all, to really put something out that Africa really as a continent has some sort of claim, as has been said in multiple articles, to be in some ways the birthplace of investment arbitration. So really the question of whether there is innovation or stagnation in investment and regional investment agreements is absolutely key, in the sense that Africa has always been a historical actor in the development of investment arbitration. There definitely is perhaps some stagnation, as my colleague Jacob Ferris was suggesting. There is also a lot of already innovative material that has been issued by regional agreements and bilateral investment agreements in Africa. And there is yet more room yet to come for more innovation. The issue is whether those that are actually made are effectively useful and relevant to the proper resolution of disputes in a peaceful manner, as arbitration is intended. So the purpose of my presentation today will be to focus on how innovation can be aimed and attained by reviewing the UNCITRAL rules, which inspired eventually the 2012 Permanent Court of Arbitration Rules, in a view to improve and innovate the African regional investment treaties. Now, before such an audience, even though we can't see you, I believe it is the UNCITRAL rules and the PCA need very little introduction, but allow me just to paint a few words about that. Suffice it to say that the UNCITRAL rules are rules that were prepared by the United Nations Commission on International Trade Law. They were first issued in 1976. They were amended in 2010, and in the course of those amendments, various developments of international arbitration and just mere technology and global evolution were taken into account. Hopefully, the Permanent Court of Arbitration needs no more than a few words of introduction also. It's an intergovernmental organization that was established in 1899, whose main purpose includes in particular the peaceful resolution of disputes, something that it does in particular by administering arbitral proceedings between states principally, but also state-related entities and state-owned entities. Now, the PCA has a seat in Africa, or a location in Africa now. Since in 2010, it opened the Mauritius office, where you can see me virtually located in, given that we are currently sadly in lockdown. So let's start with a few numbers perhaps on the situation of UNCITRAL in Africa. According to the databases, about a third of the investment agreements in force with African signatories provide for the UNCITRAL arbitration rules. This obviously includes both intra-African arbitration agreements, the bilateral investment treaties, and bilateral investment treaties that are with one African state and a third state. To those, you have to add that at least 6 investment codes issued by African countries expressly refer to the UNCITRAL rules, and about 11 institutions have found inspiration in those rules to model their own institutional rules. Clearly, the UNCITRAL rules have always been a source of inspiration for institutions around the world, but it's also the case of regional agreements in Africa, especially the model regional agreements. So the SADC SADC model BIT in particular has referred to the UNCITRAL arbitration rules, and the African Union Pan-African Investment Code that was drafted and made available to the African states in 2016 provides for UNCITRAL arbitration as the arbitration rules to be used to resolve disputes in its Article 42. Now, it's particularly interesting to note that the Pan-African Investment Code, the PIC, which is generally speaking an African consensus on the shaping of international investment law too, in the words of Professor Menge. In this continental initiative, there was a preference that was marked for UNCITRAL arbitration rules. Now, allow me to go through very quickly the advantages and disadvantages, perhaps, of using the UNCITRAL arbitration rules before I proceed to afterwards developing how inspiration can be found in the 2012 arbitration rules to really build for innovation in African regional agreements. As ad hoc arbitration rules, the UNCITRAL rules have the advantage of being particularly flexible. The parties are enabled to tailor them to their needs in each procedure. And this is something that is generally done by any institution or by any tribunal that is administering an arbitration that way. Because of their flexibility, really you can have the advantage in the UNCITRAL arbitration rules that you can provide for something that has been the topic of much debate over the past 5 to 10 years, which is the Africanization really of arbitration, and in particular investment arbitration, whether you can seat an arbitration in Africa or have an African located center that will be able to rule on the proceedings. Now, the reverse of the coin, if I may, in that sense, is that because they are ad hoc arbitral rules and they are particularly flexible, the UNCITRAL arbitration rules have the difficulty of not providing certain elements that are key to the proper and to the smooth development of arbitral proceedings. In particular, they do not provide for a particular seat, or they do not provide for a particular institution to be taking care of the arbitration. Now, to give you an example of how these UNCITRAL rules can be flexible and adapted, and actually you will have a potential disadvantage that will be immediately offset by a proper management of the arbitration agreement. One can go no further than the Morocco-Nigeria BIT, which expressly selects The Hague as the seat. So there is a reference indeed to the UNCITRAL rules, but there is already a seat that has been selected by the participants or the contracting states. Now, the UNCITRAL rules of 2010 were the ones that inspired the 2012 PCA rules. The PCA rules of 2012 were created based on the experience that the Permanent Court of Arbitration has gathered over its existence regarding the administration of arbitration proceedings, and in particular, state-related proceedings, which obviously include investor-state disputes settlement cases. These 2012 PCA rules can provide useful guidance on how to better adapt the UNCITRAL rules in cases involving states, and they could be a source of inspiration to our African regional arbitration agreements. Because they keep the tried and tested provisions of the UNCITRAL rules, they already have the advantage of being well known and of being able to rely on a corpus of elements of awards or court decisions, and they can provide some sort of confidence on the part of users. But at the same time, the 2012 PCA rules have the advantage of having been tailored to respond to factors which the PCA's institutional experience shows as relevant to state and state-controlled entities engaged in arbitration, whether it is actually commercial or investment. So let's look at the various points that perhaps would be of particular relevance in the PCA arbitration rules that could be of interest for an African regional agreement to look into when proceeding to set out an arbitration agreement in a regional BIT or a regional investment treaty or a regional investment agreement. First of all, the PCA rules provide for an inbuilt flexibility that is favorable to states, in particular regarding the distribution of time for certain submissions or for the appointment of arbitrators, because there is indeed a deadline, but there is immediately the possibility for an extension of that timeline by the International Bureau of the arbitration. This participates in ensuring that the proceedings are not only well administered, but also caters for the requirements that are proper to a state that often has multiple actors intervening in an arbitral proceeding. The PCA rules also contain a simplified designation of the appointing authority. So walking back to what the UNCITRAL rules will say, the UNCITRAL rules will have a default procedure that is a two-step procedure whereby if there is a problem in the constitution of the tribunal, you will be able to eventually seize the Secretary General of the Permanent Court of Arbitration, who will in turn appoint a person who will be the appointing authority for a specific case, and that appointing authority will be the one in charge of any challenges or appointment issues that arise during the course of the arbitral proceedings. Under the PCA rules, you do not have that two-step procedure. You have just it's a one-stop. That will be the Permanent Court of Arbitration's Secretary General. Now, this is particularly relevant, as the UNCITRAL Working Group noted, in ISDS proceedings, because that limits, obviously, the number of persons involved, and it also limits the time that is being spent on dealing with the incidents in the proceedings. It also provides for a neutral designation authority mechanism. You will have an international organization with broad-based membership, and regarding Africa, an increasing number of African states being members, that will be in charge of being the appointing authority. Now, this particular provision provides for clarity, and it provides for neutrality, two elements that are key not only for African states or African investors, but also particularly for the other side, in the sense that either the non-African state or the non-African investor will find comfort in the identification of this neutral institution intervening with regard to the issues of challenges or appointment issues. Now, all of this leads me to conclude, and I'm sorry because I am wary of time, and we have been a bit longer in our presentations with my colleagues than was initially expected. So I will be trying to summarize very briefly. This leads me to the conclusion that really it is possible for the African regional investment agreements to consider that there are innovations possible to build upon what already exists. And there are tried and tested provisions that exist. The UNCITRAL rules provide such a basis, and by being tried and tested, by being approved by so many members and so many states, they provide for a sort of a template that is agreed overall in arbitration as a functioning template. And there is no need to reinvent the wheel every single time that a new agreement is built. So on the procedural point, you can really rely on the UNCITRAL arbitration rules as a starting point, and then you can build to improve. And for the improvement and the innovation, you can rely on as a source of inspiration at least, or you can go so far as to directly not using the UNCITRAL rules and directly using the PCA rules to really inspire innovation in bilateral and multilateral investment treaties. Whether it's by including the 2012 PCA rules instead of the UNCITRAL rules, or by building a whole new mechanism based upon them. Now, as Sylvie pointed out already, there have been African states that have been intervening in the UNCITRAL working group that is currently working on the development and the reform of the ISDS system. And there is definitely room for African states to jump aboard the UNCITRAL reform train and to implement the modifications that are most relevant to answer the challenges that they face in investment arbitration and in the procedural organization of such proceedings. In that, I believe that there is definitely, as I started my presentation, room for innovation, and for that there are many instruments up that are up for grabs for African participants, and in that the UNCITRAL rules and the PCA rules provide a good start. I leave the rest of the floor to questions.
Thank you very much, Andrea Lapuzina Veronili, for the beautiful presentation, which are centered primarily on the application of the UNCITRAL arbitration rules and the PAC rules of 2012. And you cleverly landed and ascribed innovation to your own perspective. And I love the way you went around all that presentation that you did. Now over to the floor. We had requested for questions, and a good number of questions have been posted, and I would be treating them one after the other. I would call on Jacquel to please take the first question, which comes from Emeka Onyeka. It says, how and what do you think the African countries need to do to harmonize the inconsistencies, as you noted in the various BITs and MITs, in the light of the AFTA investment protocol, in order to have a functional, effective, and innovative dispute resolution mechanism that works for Africa? Jacquel.
Thank you, Chief Okino. When we look at, and I think one of the primary document that was also discussed in the previous session was the Pan-African Investment Code. And that essentially, if you look at that, the code, which is a non-binding document, it also speaks to the fact that that code should ultimately be the basis for the AFCFTA investment protocol. And in the article, one of the important parts of that article, although it's non-binding, it demonstrates to us also the divergence of views of different African states in terms of certain policy considerations. And one clear thing you can see from the code, which we'll probably also see in the investment protocol, is the lack of reference to FET. And again, this is an approach probably you can see from a South African government perspective also in terms of influencing that the South African policy position, and you can see that also in the SADC model model a BIT is that the South African state, and it seems the grouping of SADC member states, is against, to a large extent, the principle of FET. And there is a proposal to develop a so-called principle called fair administrative treatment. Now, that also flows into what you find in the dispute resolution portion of the code. So in harmonizing investment protocol and BITs and MITs from an African continental perspective, you're dealing with 55 states. 54 of the states have signed the AFCFTA agreement. I think 34 has ratified it to date, and there's negotiations on the investment protocol. And each of these states have different, at a different developmental stage, where you have industrialist economies like South Africa, you have economies that still need more capital investment. So you need to balance all of these interests into one document in respect of 54 countries. It's going to be very difficult. So to make sure that you deal with all the different issues where on the one side, some states would say, we want FET in it. And on the other side, some states would say, no, let's have a so-called, say, fair administrative treatment, if that eventually gets into the investment protocol. So I agree that there's a need for harmonization. There's a lot of inconsistency. And hopefully one of the big challenges would be to deal with all the BITs, inter-Africa BITs, not BITs with any of the foreign jurisdictions, but how do you deal with inter-Africa BITs, which in itself is contradictory in terms of the standards of protection. And if we take the code, the Pan-African Investment Code as a reference, again, if you look at Article 3.2, it speaks to the fact that it says, and I can read, it says member states may agree that this code could be reviewed to become a binding instrument, and then importantly, to replace inter-Africa bilateral investment treaties or investment chapters in inter-Africa trade agreements after the period. So I think that's something that would potentially also get into the investment protocol, because there's a need. The only way we can harmonize it is by also making sure we do away with all the inter-Africa investment treaties, similar to what is happening in Europe, to have a harmonized process and also a harmonized dispute resolution process. And the question is, what will that be? Will it be a Pan-African Investment Court? And that's also a debate, and similar to what's happening in Europe. Or will it be arbitration? And we know that some states like South Africa, again, not against arbitration, but against the principle of investor-state arbitration and issues of sovereignty. So hopefully that answers the question. Any of the other panel, I think, can also express their view. Thank you.
Thank you very much, Jacquel. The next question is for Andrea. And the question is, I think it has to do with appointments. It says, do you see value in interacting with directories of African practitioners that are currently being published as far as innovation on African arbitration appointments is concerned? And that question is from Tabitha Joy Raure. Tabitha Joy Raure. Andrea, please, you have the floor.
Thank you very much for this question and for this interesting point that is raised regarding an issue that has been really on the top of everyone's lists, especially since last year. It was one of the key topics, if I recall, of the Paris Arbitration Week at one point. So the question calls for a good number of potential replies, but the issue is that I would focus on is really whether it's possible to interact with such directories. Of course, there are arbitration institutions that are the ones creating those directories, and they are therefore going to be contacting the persons that they know to be competent in the field of international arbitration, and they will therefore provide a sort of insurance or guarantee that the persons that are being selected will be adequate adjudicators in arbitration cases. Now, in doing so, they also promote for the diversity of arbitral appointments, and in that there is definitely a value in interacting with the various institutions and in keeping in touch, for institutions to keep in touch with one another, and for people for arbitration users to rely on those directories to appoint people, because again, this is something that is key when you're thinking of the issue of arbitral appointments, is who appoints. It's not so much the institutions, it's really the parties. So if there is only an interest in these directories, if they are actually made available and people actually look at them and actually implement them. Now, one of the, if I'm without going on a sad note, I would put some caveats on this. Directories of African practitioners, as all directories of any practitioners or any field, can include names just because they are a compilation of contacts. That's one risk. And there is also the risk of having too many directories. So there comes a point where you don't know which directory to trust. And in that, I believe that there is perhaps a bit of improvement and innovation to be done, whether it's by centralizing them or maybe finding a proper way of doing. I know that the African Arbitration Association has a directory, and that is probably one that you could want to go to as a first step. I hope to have answered the question of Ms. Tabitha Joy-Ray. I'm sorry, I don't see your name anymore, so
Yes.
I apologize if I have butchered it.
Thank you very much, Andrea. Another question, this one for Dr. Sylvie. It says, what is your view? Do you reckon that the current OHADA investment provisions respect investment arbitration requirements?
This is a very tricky question, Chief. I would say yes, the respect, because the person who, if you want to put into practice the OHADA provision, arbitrators. So I think that on that rejoin just what we were saying about the directories of different institutions. I think that if we have a good tribunal made of practitioners who knows or who master the arbitration, being it commercial or investment, they should make all their first to really make the arbitration respect the requirement that that we could have from investment arbitration. So considering the fact that now we have these provisions dealing with arbitration investment, if there is a dispute that have to be settled within the OHADA area, is the duty of the arbitral tribunal who will be sitting in the case to make it clear, or to make all it's possible to have the requirements of investment arbitration be respected. So it's a door which have been opened, and now for the moment, the practitioner has to do all to make this requirement of investment arbitration be respected, and also our national courts when they have to deal with awards coming from investment disputes within the OHADA area.
Thank you very much, Dr. Sylvie, for that response. The next question is directed again at Jacquel, and it comes from Rwanda. The question reads, Jacquel had talked about the availability of a beautiful SADC template on BIT, but clarified that I had not seen where it's being used. He wants you to share your views about the existence of these documents and policies and the like, and to dwell on the areas to which is being neglected, and wants to know the consequences of that on the settlement of arbitration disputes. Jacquel, you have the floor, please.
Thank you, Chief. Thank you, Prosper, for the question. So the beautiful document I referred to is the SADC model BIT. There's been 2 iterations. So there's one that's in the public domain, and there's one that's not yet in the public domain. It's kept secret somewhere, hopefully in Gaborone, Botswana, in the safe. But the problem with these type of policy documents, so one of the fundamental principles of the SADC protocol on finance and investment, so it has a section that deals with the harmonization of the investment framework or landscape within SADC. Now, this SADC model BIT is essentially a project that flows from the harmonization project. Now, so, and the SADC model BIT has a number of innovative features, as I've mentioned, in terms of more substantive obligations on investors, and it talks about counterclaims for state, consolidation of arbitrations, and so on. But in my personal experience, I've never seen it in any of the other new BITs, and there's a very few that has been included by SADC member states, or any drafts floating around in terms of each host state in their own development of their BITs. So from a policy perspective, yes, it's laudable and it's good, but the problem is the harmonization, because each SADC member state still has different BITs. So although South Africa has terminated also some BITs, not all BITs have been terminated. So you still have the old generation BITs. So some of them are with Mauritius, some of them are, so this is now SADC member states, some of them are with Zimbabwe, some of them are with Senegal, some of them are with the other states like Russia, South Korea. So you have a suite of old generation BITs, but you also don't have any process by states in SADC to change those BITs, to harmonize them and align them with the new dogma and thinking on BITs, still having ISDS in it, but not as we would want it to be. So, and that's the problem with what we're facing, is against the issue of, we have all these, and it's great, wonderful ideas, and it's innovative, but we're not implementing those ourselves. And hopefully it will come out again through the African Investment Protocol. So our hopes is in the protocol, and we'll see how that goes. Thank you.
Thank you very much, Jacquel. There's yet another question, which I think is directed at you. Says it's a follow-up to your presentation. Are we not continually reinventing the wheel with all the instruments being put forward? And can you come up with a panacea instrument that will be widely accepted by all African nations? I wonder if you can have a bite of that, Jacquel.
Thank you, Chief. I think it comes back to the issue of harmonization of the instruments, ultimately. So it will be ideal to have a uniform instrument for the entire African continent through the investment protocol. But we have 54 member states. Sorry, 54. There's 55 states, and there's 54 who signed the AFCFTA founding agreement. But all of them have different interests. All of them have different developmental needs, And if we just look at the Pan-African Investment Code, and we can take our guide from that, saying that's probably more or less where we will land in terms of getting something that's more harmonized. But then from an African state perspective, we need to then, similar to what Europe is in the process of doing, is we need to get rid of all the intra-Africa BITs. That will create certainty amongst intra-African investors. Hopefully that answers the question.
Thank you, Jaco. This about brings us to the end of this session. But before we all leave formally, permit me on behalf of panel 2 sessionists, all the panelists, to thank the organizers once again for deeming it fit to have these distinguished Africans to bring their perspectives on the topic that has been well treated this morning stroke afternoon. Secondly, I want to thank each and every one of the panelists, and in no particular order. I'll start with Jaco Ferris. Thanks so much for making our time, and thank you for making yourself available to this conference and this session, and to being able to answer all the questions directed at you. Likewise, Dr. Sylvie Beboye Bongo, I want to thank you. I know you are operating from multi-jurisdiction, Paris and when it's convenient, Cameroon. We appreciate you, and thank you for the time made out to be part of this. Lastly, I want to thank Andrea Lapozina Veronelli, and I want to thank her specially because Andrea really is in a state where she's expecting a visitor, and she had warned me ahead of time that she hopes she'll be able to see herself through this session. Andrea, I wish you a safe delivery. I know you didn't intend it for me to disclose to the whole of Africa, but you've been strong, and for somebody that has been carrying a load for 9 months, and anything could happen, yet you braved it to be part of this. I commend you greatly, and I wish you safe delivery. So, ladies and gentlemen, thanks so much for being part of this session, and long live the African Arbitration Association. Thank you.
Thank you, Chief. Thank you.
Thank you, everyone.